So I have a very brief disclosure here, just to make sure that there's no confusion. The problem is each one of you may think your businesses are identical and you'll chat and whatnot, but when it gets down into the details, they're very different. And things that I say to answer your question may sound wonderful to you, but it doesn't apply until the lawyer has actually heard all your facts. So basically, learn as much as you can in this session, but when it comes time to actually make a decision for your business, get advice, whether it's an accounting thing or a legal thing. Never wing it. It's just the risk is too great. Enough said about that. Okay, so I was given 3 basic things to just briefly talk about, and I did. It's just to encourage questions in case it's pertinent. But then, as soon as we move through the slides, and while we're going through the slides, ask any questions you have. So basically, the takeaway I'd like you to have from this slide is there's 2 ways to look at things. There's the perfect world and the real world. So in the perfect world, if you don't need a whole lot of help, you hire a contractor. And if you need constant help for a long period of time, you hire an employee. And these market forces induce the employee to work for less in the expectation that they're going to get all sorts of benefits and they're taken care of. And the contractor to charge more because they know that it's period work and it could be here today and it's gone tomorrow and that sort of thing. But it really isn't the perfect world, so you really do need to shop around. Sometimes contractors may make no sense, even if it's a short-term thing, or sometimes employees may make no sense, that you could always work through contractors. So it really depends on what work you need done and what the market is like for the type of people that you need to assist you with that work. But a couple things that I want to point out is that some people view contractors as a way to avoid the difficulty of having an employee, and Revenue Canada disagrees with you. So read that publication when you have an opportunity and understand that on its most basic level, if this person derives all of their income from you, as much as they want to call themselves a contractor, they're not. They're an employee. So understand that publication. Have a chat with your accountant, who will definitely understand this issue quite well, and make decisions accordingly based on what works best for you, as far as contractors or employees go. This, I wasn't exactly certain what they were after, but I researched it, and basically, from my research, the biggest focus on this whole issue of franchising versus licensing is the idea that you may have some kind of intellectual property. So there's sort of 3 main kinds of property that lawyers look at. There's real estate, there's personal property, and then this special subset of personal property called intellectual property. And there's ways of dealing with this property and protecting the property and owning the property. And franchising is one way to protect your property if you want to branch out, and licensing is another. And the basic point in these slides is that franchising is much more onerous, and you need to make sure that you get the proper kind of an IP lawyer to draft up an agreement in such a way that it deals with the law where it's at. There's about, I believe, 5 provinces right now that have very specific, could be 4 provinces that have very specific franchising laws, and BC is this close to having them. And so what happens is you can be deemed, once a law comes out, to be doing something. So you might be thinking that you're licensing out your ideas, but in fact you're franchising them. Just because of the way you're doing it, it falls under that law. And generally, at least in my research, the franchising legislation that's out there in the other provinces seems to be protecting the person who's obtaining the franchise from you and expecting a lot from you. And so just be careful if you need to move into this kind of an area with your idea when you're branching out as to whether or not you're licensing or whether or not you're franchising. And if you're considering franchising or licensing for that matter, keep your eyes open for this new legislation that's likely to come out in BC, and just be aware of it. And then I've got a bit of a cautionary note down there saying that this is a very specific area. IP law tends to be broken down into copyrights, patents, and trademarks. and they all have very specific rules about how you protect them. And in exchange for your coming up with these wonderful ideas and following all the rules, you get this incredible protection. But on the other hand, since you're getting this incredible protection, you're expected to follow all the rules, and if you mess it up in any way, you'll lose that protection, basically, which is why there are IP lawyers. All right, so employment law. So when I was given that subject, I thought, okay, if I was wanting to consider the issue of employment law, what 4 things can I break it down to? And I thought, okay, well, we can talk about when to hire, how to manage in that relationship, and then finally, how to fire, focusing on it from a legal side. Why would a lawyer be interested in this stuff? Because it's much more complicated for you. There's a lot more to think than just the legal aspects. So, but right off the bat, and this is more of a cost-benefit analysis, it's that whole issue of what we were talking about before of contractor versus employees. There's a lot of requirements that are thrown on you as an employer if you choose to hire an employee. Make sure it's worth your while. I had a client that was asking me for advice. He just never seemed to be able to win. When he had an employee, he said, you know, I really should have someone contracted to do this thing. It's horrible being an employer. And then he would let the person go, and he wasn't getting the service he wanted out of the contract. Oh, it's horrible working with a contractor. I really needed an employee. And you got to weigh the pros and cons and decide what's best for your business and be ready for it. When you do hire, you want to protect yourself. It's always about risk and reducing liability, setting proper expectations, things like that. Written contracts are always better than verbal in that, you know, I'll have 2 people in a room, a buyer and a seller or whatnot, and what they're saying verbally is very simple, but then I'll take what the 2 of them say and I will put it to paper and I'll present it to them. Oh, no. But that's what you're saying. Yeah, but that's not what I meant. There's something about distilling something to writing that forces people to haggle about the issues before the agreement starts rather than afterwards and fighting about it. Something to consider because of the requirements of notice and severance and all that is to consider fixed term employment if you know how long you want this employee to work, because it makes ending the relationship a little easier as long as you're careful to buy yourself a little bit of protection. So let's say you know you want to hire an employee for 2 years. So you just simply set out a 2-year employment contract. The risk to that is a month later, everything changes in your business plan. Your business makes no sense. You still owe them 1 year and 11 months worth of employment. And you hadn't thought of that because a month earlier you projected 20 years of business down the road, and 2 years seemed like no big deal. So you put a clause in that contract that says, I can fire you under these circumstances, a month's notice, whatever, and you can quit under these circumstances, a month's notice. And if I don't give you a month's notice, I'll give you a month's pay in lieu of notice. But you put it in the contract, but doing that makes the separation from that employee easier than an open-ended kind of an indefinite term employment agreement. So it really depends on what your plans are for this employee. Odds are, if you offer fixed-term employment, you'll probably pay more per hour, depending on how the market is, because people don't like losing their job, basically. So there's all sorts of things to focus on, but one of the biggest things is remembering this idea that you need as an employer to accommodate. It comes back to that whole master and servant thing that is carried forward in our law through all these years. You're the strong party, they're the weak party. You need to be reasonable. So then you need to develop policies where if you're not getting the performance you want, you in a reasonable way, and usually it should be written, deal with the issue, explain clearly what you want, and then you explain it a second time. I go with the whole 3 strikes you're out scenario. Explain it a third time. You've been reasonable, you've offered possible retraining or whatever it is that it's reasonable to do, and you can talk to your lawyer about that when you run into that problem, to accommodate, and then you deal with things like firing or whatever you need to do for all sorts of reasons. Number one is it's just good business. You can have an incredible employee that you're not training well and you're not dealing with, and they think that they're great running over here when you want them running over there. So it deals with that, but as a lawyer, I look more at the whole liability side of things. Sometimes when you finally decide to fire, you can run afoul of some kind of human rights law. And one of the best ways to make sure you're not running afoul of that is accommodate properly. And be very careful and measured in what you do and why you're doing it, and put it to writing and read books and understand your responsibilities and understand human rights legislation, and be careful what you say and do, because it could be you may not have meant that, but it can be interpreted incorrectly. And normally at law, you have the right to fire anybody at any time you want to, as long as you deal with the law in relation to notice. People are supposed to get a reasonable amount of time to go find a new job. So whether you want to give them verbal notice and say your job's gone in 5 months, and take the risk that they become poison in the workplace and say horrible things about your business to all your other employees and hurt your relationship with your clients, or you think it's a better idea to hand them a check for 5 months or 2 months or whatever on advice from your lawyer makes sense to do based on the law, that's your choice. But you do need to take care of that whole notice issue. And then the other thing is to try to put on their hat, right? A wonderful way is to always start off with here's the 27 things I like about you. Here's the 3 things we really, really need to deal with. But it's not you, these are just issues. And then you go from there.
Brian, isn't there some special terminology or some special situations you have to work when it comes to substance abuse?
Right, and that's got to do with that whole issue I was warning you about, human rights law.
Yeah.
So there's all see what it is people would have a grievance. They would say, I'm being ripped off in society, unlike any of you others, because of my special circumstance. And the law can either recognize it or not recognize it. For all I know, there's a special movement out there right now that if I'm stealing from you, it's because I have an issue. That's all. You have to help me not steal from you. And so once again, you go to an employment law lawyer and you say, look, here's the issue I'm dealing with. Does this in any way impinge on human rights law? I don't want to be sued, because tribunals are very cut and dry. When they make their decision under human rights law, once you're in the hands of a tribunal and you're deemed the strong party, for instance, if you're a landlord in a residential tenancy, there's a lot of stuff that people around the coffee table would say, well, why is that your fault? Well, it's because the law says it is. So be very careful about all sorts of things that you think are an employee, personal problem, when in fact it's now fallen under the banner of human rights. And and it's not easy to get rid of people for cause. At the end of the day, you're going to make a decision. You should be an honorable person and you should not discriminate and yada, yada, yada. But at the end of the day, you're a business and you have to make business decisions. So is there any magic way to not discriminate? We all discriminate. We just all discriminate against different things. And so if there's evidence that you've been discriminating, or that you've discriminated, and it's not very expensive to take you to human rights tribunals, because maybe it's $50. That's not good. So understand human rights law. I don't see anybody in here that wants to be what's the word? Prejudice kind of a person or whatever. Anyways, but at the end of the day, there's way more factors as to whether or not you're hiring the person as to whether or not they're a drug user. Because odds are, if they're a drug user, they may have these 27 other characteristics that you would never hire someone for, even if they weren't a drug user. And so that's why I'm not hiring them. And focus on that. But make sure that, and I don't even know that there's any positive requirement for you to record why you don't hire people. Because like I say, at the end of the day, whatever reason that someone nails you under the human rights legislation is probably one of 20 reasons why you did the thing. But yeah, once they are your employee, everything changes. There's this huge duty to accommodate. Make sure you're doing it right, and make sure you get advice if you're having problems with this employee, and make sure you don't knee-jerk and fire someone, because you can. I'll give you an example. At Case Law, there was a gentleman who was a very, very brilliant engineer, and he had this problem. I think it was bipolar disorder, where he was up and he was down like crazy. And he had worked at some company for 15 years, made it this incredible name for himself, and but they knew about his problem, they accommodated him, they worked around it, and he was a great employee. He got this opportunity to work in this NASA-like outfit, and because they didn't know anything about his condition, and because it was such a stressful environment, he lost it. And I don't know whether he was walking around with underwear on his head or just what he was doing, but whatever it was, 10 days in, boom, he was fired. And he took them to human rights court, and he won. And they had to pay him, I can't remember whether it was 80 or 250 or some ridiculous amount of money because of how he was damaged, how valuable he was as an employee, what he could have expected to earn. The bottom line is if they had gone to a lawyer before they made this knee-jerk decision and gotten some advice and said, if they had explained why they were firing this guy, the lawyer might have said, hey, that's human rights. This guy's got a mental illness he's trying to work through. You can't just fire him without any attempt to accommodate and help him along. And it would save them a fortune. So I want you to balance two things. On the one hand, I want you to read like crazy, learn from other people's mistakes. On the other hand, I don't want you to think that because you've read, you're either now your own accountant or you're your own lawyer. Always get specific advice before you do things from people that have seen even more than what you're going to learn about when you read. So all I did is I went to Self Counsel Press. They had a website and they had a little button that said books on sale. So I hit click, and then I thought, wonder what books people here might be interested in buying. And these looked good, so I copied the titles to show you that these guys sell these books. That at least the last time I looked, they were on sale. Read as much as you can. Go to the public library. Go to the law library. But like I say, don't just rip off contracts or accounting ideas or whatever and go on this do-it-yourself, because it's not worth the risk. But at least if you read as much as you possibly can, you'll probably ask far better questions of your lawyer and your accountant and make better use of the time and help your lawyer or your accountant make better decisions because you can explain what you want better. You're sort of talking their language. So my advice to all of my clients when it comes to incorporation, whether it be multiple levels of incorporation or just incorporation out front, is to start with your accountant. Because about 85 to even 90% of the reason you're going to do this is tax driven. And your accountant will have already decided that, I can do so much more for you if you have a holding company and these other separated corporations. Or he may say, no, I can't. You're going to be paying a lawyer to help you with 5 corporations, and you're going to pay me to file 5 corporate tax returns, when in reality you can achieve all the goals that you've expressed to me through this one corporation. So that's 90% of what drives it. But is it doable? It sure is, and it's often done, and it just depends on what you're doing. And if there's a way to save a lot of taxes in a legitimate fashion, then your accountant will recommend that thing. There's also all sorts of liability issues you can be considering to protect one corporation from another, but more often than not, it's based on what the accountant's able to do with dividends and whatnot, and the way he can work things through one company and up into another. But first off, it's better to get a real good understanding of incorporation and why you incorporate, and then for a small subset of people, you'll start considering the whole issue of holding companies. And basically, my advice is to have a very close relationship with your accountant and explain what you're doing and why you're doing. And because I consider most clients, they should operate on a pull system. Lawyers and accountants are nervous to not overbill. If you're not pulling, they're not thinking about that issue. But if you tell them about stuff, and you'll spend a lot more time with your accountant than you will with your lawyer normally, they're not going to give you the advice because you didn't tell them. And I've had people all upset that, they should have incorporated 25 years ago, but my darn accountant never told me to do that. And I'm thinking, well, maybe you didn't discuss things well enough. Or maybe it was the accountant, don't know. But really, pull from your accountant especially. Throw things at them, just like what you're saying now. When should I incorporate? Why should I incorporate? Give them facts that they may not know. Yeah, I'm only making $80,000 this year, but I project that I'll be making $400,000 next year, and then act based on that advice.